Hello, my name is Lukas Götti and I'm an assistant at the Department of Criminal Law at the University of Fribourg, Switzerland. The topic of my talk will be on the question whether the Swiss Federal Council has the authority to issue ordinances directly based on the Constitution containing the harshest criminal penalties that are possible under Swiss criminal law, namely custodial sentences, in German Freiheitsstrafe, or in French peine privative de liberté. I will ask this question because the Federal Council has done precisely that in its very influential Ordinance on Measures to Combat the Coronavirus, frequently called COVID-19 Ordinance 2. In this ordinance, the Federal Council has taken many measures and it also has been updated and changed many times. I will base my argumentation on the COVID-19 ordinance in its version of 17th of April 2020. In this version, Article 6, Paragraph 1 prohibited the organization of public and private events, including sports events and events of associations. Paragraph 2 of the same article specified a number of publicly accessible establishments that had to be closed, listing, for example, shops, restaurants, nightclubs and leisure and entertainment services, such as museums, cinemas, ski resorts and so on. Paragraph 3 then went on to establish some exceptions to this rule, and paragraph 4 obligates those establishments that are part of the exception to follow the recommendations, as they were called, of the Federal Office of Public Health concerning hygiene and social distancing. So in short, Article 6 of the COVID-19 Ordinance 2 prohibited the opening of a good number of shops and leisure and entertainment services. Article 10F Paragraph 1 of the COVID-19 Ordinance 2 treats the criminal provisions that are applicable in the case of a violation of Article 6. Now, the wording in English of Article 10F Paragraph 1 of the COVID-19 Ordinance 2 is no longer available today, so the following translation of the German and French version is mine and not an official one. It reads in the following way. Unless a more serious offense under the Criminal Code has been committed, any person who willfully opposes measures of Article 6 is liable to a custodial sentence not exceeding 3 years or to a monetary penalty. End of citation. So this is the situation as it was on the 17th of April 2020. Article 6 prohibiting a good number of shops and services to be open, and Article 10F Paragraph 1 imposing a criminal sanction going from monetary penalty up to custodial sentences not exceeding 3 years. Now, before I can come to the question at hand, namely whether the Federal Council was actually competent to issue such a criminal sanction, I have to lose some words over the foundation on which the COVID-19 Ordinance 2 has been issued. Officially and also literally, the ordinance has been based on a federal law, more precisely on Article 7 of the Federal Law on Epidemics, to which unfortunately there is no English version available, so the following is again my translation. Article 7 of the Federal Law on Epidemics, as I translate it, therefore reads as follows. If an extraordinary situation necessitates it, the Federal Council can issue the necessary measures for the whole country or for individual parts of it. End of citation. Now, the crux with this Article 7 is that in the dispatch by the Federal Administration concerning the law on epidemics, which is a very important source of interpretation of the law, the Federal Administration wrote that Article 7 is of declaratory nature and simply repeats the competences which the Federal Council, being the government, already possesses based on Article 185, Paragraph 3 of the Swiss Constitution. This Article 185, Paragraph 3 of the Constitution reads as follows. It, meaning the Federal Council, may in direct application of this article issue ordinances and rulings in order to counter existing or imminent threats of serious disruption to public order or internal or external security. Such ordinances must be limited in duration. End of citation. In order to answer the question whether the Federal Council had the competence to issue custodial sentences in an ordinance, I will base my argumentation on the assumption that the COVID-19 Ordinance 2 was based directly on the Constitution and not on Article 7 of the Law on Epidemics. That is because the argument that the Federal Council was in fact competent to issue custodial sentences is stronger if the COVID-19 Ordinance is based on the Constitution, because the Federal Court has allowed for precisely this in some past rulings, and because the law on epidemics already contains criminal provisions, which makes it very unlikely, in the word of the Federal Office of Justice, that the legislator wanted to allow the Federal Council to issue further criminal provisions based on this law on epidemics. And because I will argue against the competence for the Federal Council to issue such custodial sentences in an ordinance, I will try to make the case for precisely this competence as strong as possible. Now let's turn to what the Federal Court, being the Supreme Court of Switzerland, has said about the competence of the Federal Council to issue custodial sentences in ordinances based on Article 185, paragraph 3 of the Constitution. The probably most important case concerning this question is a decision from the 10th of January 1997. At this time, the Federal Council had issued an ordinance based on the predecessor of today's Article 185, paragraph 3. This ordinance prohibited, among other things, all citizens from the former Yugoslav Republic to bear or carry guns in the public. The ordinance was issued in the context of the ethnic conflicts, wars of independence and insurgencies in the former Yugoslavia in the 1990s. Because they were living at the time, and still today, many citizens of the former Yugoslavia in Switzerland, the authorities and the Federal Council feared conflicts between former Yugoslavian citizens in Switzerland. So the Federal Council prohibited, among other things, all former Yugoslavian citizens to wear guns in public. In the same ordinance, the Federal Council imposed custodial sentences up to 3 years, or a fine up to 100,000 Swiss francs on anyone who in fact did bear a gun in public and was a former citizen of the Yugoslav Republic. The Federal Court decided in that the Federal Council was competent to issue those custodial sentences for the following reasons. Criminal penalties are necessary to enforce the prohibitions whose non-respect they punish. If the public goods are very important and if the dangers which threaten those public goods are imminent and serious, as by the way Article 185 paragraph 3 demands for its application, then even custodial sentences may be deemed necessary to enforce these prohibitions. There have been other arguments in this precise decisions, for instance that at the moment there was a legal reform going on which would allow for such ordinances containing custodial sentences to be issued in the future. But this cannot be a relevant argument to legitimize custodial sentences that are already in force, because something that is just in preparation is not yet in force by definition and cannot therefore be invoked to justify something as harsh as custodial sentences. So the main argument is custodial sentences are necessary for the enforcement of the prohibitions of the ordinance, and therefore they are necessary in order to counter existing or imminent threats of serious disruption to public order or internal or external security in the sense of Article 185, paragraph 3 of the Constitution. Now there are two reasons why I think this is not the case. First, criminal law is not a tool to enforce a given behavior. To enforce a behavior must mean that the desired behavior will take place no matter what, if necessary by force or by coercion. This is typically what the police or the law of the police, or more widely administrative law, is for. Under Swiss law, the police does not need a criminal offense norm in order to be competent to act. Even if a given behavior is absolutely legal, the police has the authority to stop a given behavior if it causes danger. The prime example are bystanders who are too close to a dangerous place or an accident. They can be sent away by the police. Custodial sentences, on the other hand, as criminal law, are only applicable in retrospective, namely when a given legal obligation has already and necessarily been violated. But if a legal obligation has been violated, then the pronunciation of a custodial sentence will not enforce the obligation. In the case of a former Yugoslav citizen who bears arms in public, the often lengthy criminal trial with the possibility to appeal will most certainly not enforce the obligation not to bear or carry arms in the relevant moment. What will, on the other hand, enforce the obligation immediately is a confiscation of the gun. A confiscation is of course possible without a criminal offense, especially when an ordinance of the Federal Council forbids to bear guns in public. The same goes for the obligation under the COVID-19 Ordinance 2 to keep certain establishments closed. If somebody would illegally open such an establishment, then the only way to enforce or to make sure that this legal obligation is respected, if necessary by force, is to send the police there and close the establishment down. The imposition of a fine or of a custodial sentence will not do the job, at least not immediately, for the same reason as before. If one does say enforcement, but really means, and that's the second reason I have against this argumentation, if one does say enforcement, but really means negative general prevention or deterrence, then this too generates some important problems. The biggest being that the empirical standings of negative general prevention or deterrence are extremely weak. You can almost open up any given criminology book, fast forward to the chapter about general prevention to find statements like the one in Karl Ludwig Kuhn's and Tobias Singelstein's book Criminologie, 7th edition, on page 292. This again is my translation and not an official one. In summary, Singelstein and Kuhn's write on page 292, in summary, there are certain indications for the significance of positive general prevention for the stabilization of norm acceptance, whereby a symbolic disapproval of the violation of the law suffices and as a rule does not have to consist in a formal punishment. The belief, on the other hand, in deterrence has almost no empirical ground. The most plausible it gets is for petty offenses, and in this respect only with a weak empirical validation. End of citation. So much for the deterrent effect of criminal sanctions. If custodial sentences are not equipped and not even destined to enforce prohibitions, which is a job for police law or police measures, which of course are applicable in the case of prohibitions based on Article 185 paragraph 3 of the Constitution, and if the empirical basis of deterrence are extremely doubtful, then criminal sanctions, and especially the harshest ones being custodial sentences under Swiss criminal law, do not appear to be necessary in order to protect the public safety and order. And if they are not necessary, the Federal Council is not competent to issue them in an ordinance based on Article 185 paragraph 3 of the Constitution, and even less so based on Article 7 of the Federal Law on Epidemics. Now, this of course is a minority opinion which is not shared by the Federal Council, by the Federal Court so far, and by the majority of legal commentators in Switzerland. But it is my opinion for the above mentioned reasons. Thank you very much for your attention and have a lovely day.